This video is made for educational purposes only and cannot be taken as legal advice. Lord Justice William Davis. This is the judgment of the court to which we both made substantial contributions. Between September and November 2021, a series of protests was carried out by members of a group calling itself Insulate Britain. Many protesters blocked motorways and other roads, usually by sitting down on and or gluing themselves to the road's surface and so preventing the flow of traffic. Others went onto the hard shoulder of motorways so as to endanger themselves and to distract the fast-moving traffic on the motorways. On the 21st of September 2021, Lavender J. granted the claimant an injunction to restrain such activity on the M25 motorway, the order. This is the third in a series of applications made by the claimant for the committal for contempt of court of those it says have breached the order. The first application was determined on the 17th of November 2021, National Highways Limited v. Anna Hayatawin and others, 2021. At the time of that hearing, the protests were continuing to take place. The Divisional Court, Dame Victoria Sharp P. and Chamberlain J., dealt with 9 defendants who the claimant alleged had, on the 8th of October 2021, breached the order. The court found that the breaches of the order were proved. The defendants were committed to prison for terms of between 3 and 6 months. In the absence of any reasonable basis for concluding that the defendants would comply with the court's orders in the future, the court did not consider that it would be right to suspend the orders for committal. The defendants to that application included Ben Taylor and Benjamin Bewes. They were committed to prison for terms of 6 months and 4 months respectively. The second application was determined on the 15th of December 2021, National Highways Limited v. Benjamin Bewes and others, 2021. By that stage the series of protests had come to an end, and no further protests were planned in the immediate future. The Divisional Court, Dingemans L.J. and Johnson J., dealt with 9 defendants who had on the 27th of October 2021, and, in one case, also on the 8th of October 2021, breached the order. Again, the breaches of the order were found proved. The defendants to that application included Benjamin Bewes, Biff Whipster, Diana Warner, Paul Sheikey, Ruth Jarman, Stephen Gower, Stephen Pritchard and Sue Parfitt. Benjamin Bewes was committed to prison for a term of 30 days to run consecutively to the 4-month term that had been imposed following the first application. Diana Warner, who initially failed to attend the hearing, was committed to prison for a term of 2 months. Biff Whipster, who had acted in breach of the injunction on 2 separate occasions, was committed to prison for consecutive terms of 2 months and 30 days. The order for committal being suspended for a period of 2 years on condition that he must not take any of the steps that are forbidden by the order. The remaining defendants were committed to prison for terms of 2 months, the orders being suspended on the same terms. The court decided that there was a principled basis to suspend the orders for committal in those cases because the protests were not continuing. A dialogue had started to take place between the court and the defendants, and because of what the court had heard in each individual case. See per Dingemans L.J. at 57. This present application concerns 3 further protest events that took place on the M25, 2 on the 29th of October 2021 and 1 on the 2nd of November 2021. Each of the defendants took part in one of those events. The claimant says that each defendant thereby breached the order. It seeks an order determining that the defendants are in contempt of court and providing for their committal or other sanction. The defendants each accept that they were validly served with the order. In relation to the events on the 29th of October 2021, the relevant defendants admit that they breached the order in the terms alleged by the claimant, and that they are therefore in contempt of court. The issue for the court in those cases is the sanction that should be imposed on each defendant. 3 defendants, Orne Springerham, Jessica Corsby, and Liam Norton, are said to have breached the order by their acts on the 2nd of November 2021. On behalf of Jessica Corsby, Mr. Owen Greenhall argues that the claimant cannot prove a breach of the order by any defendant on that date. Mr. Springerham and Mr. Norton expressly dissociate themselves from that submission. They assert that they were in breach of the order. We are satisfied that their purported admissions cannot prevail if in fact and law Mr. Greenhall is correct. On the 21st of September 2021, the claimant made an urgent application for an interim injunction against persons unknown causing the blocking, endangering, slowing down, obstructing or otherwise preventing the free flow of traffic onto or along the M25 motorway for the purposes of protesting. Lavender J. made an order the same day. The order defined the M25 as the London Orbital Motorway including but not limited to the verges, Central Reservation, on and off-slip roads, overbridges and underbridges including the Dartford Crossing and Queen Elizabeth II Bridge, and any apparatus related to that motorway. It forbids the persons against whom the order was made from 1. Blocking, endangering, slowing down, preventing, or obstructing the free flow of traffic onto or along or off the M25 for the purposes of protesting. 2. Causing damage to the surface or to any apparatus on or around the M25 including but not limited to painting, damaging by fire, or affixing any item or structure thereto. 3. Affixing themselves to any other person or object on the M25. 4. Erecting any structure on the M25. 5. Tunneling in the vicinity of the M25. 6. Entering onto the M25 unless in a motor vehicle. 7. Abandoning any vehicle or item on the M25 with the intention of causing an obstruction. 8. Refusing to leave the area of the M25 when asked to do so by a police constable, National Highways Traffic Officer or High Court Enforcement Officer. 9. Causing, assisting or encouraging any other person to do any of the prohibited acts above. 10. Continuing any of the prohibited acts above. The order stated in bold capitalized text that breach of the order may lead to imprisonment, or a fine, or seizure of assets. Each of the defendants accepts that they were validly served with the order, in some instances by means of forms of alternative service that had been authorized by the court. Protests on the M25 following the order. The reaction to the order from Insulate Britain was described by Dame Victoria Sharp. 15. On various dates and in various locations, Insulate Britain protesters publicly burned copies of the M25 order. 16. On the 28th of September 2021, Insulate Britain posted an article on its website in these terms. Injunction. What injunction? Yesterday, 52 people blocked the M25, in breach of the terms of an injunction granted to the Highways Agency on the 22nd of September. A second injunction was granted on the 24th of September covering the A2, A20 and A20/70 trunk roads and M2 and M20 motorway, after an Insulate Britain action outside the port of Dover last Thursday. Insulate Britain says actions will continue until the government makes a meaningful commitment to insulate all of Britain's 29 million leaky homes by 2030, which are among the oldest and most energy inefficient in Europe. On the 29th of September 2021, there was a further post as follows: the second time today. Insulate Britain has returned for a second time today to block the M25 at Swanley, Junction 3. Today's actions are in breach of a High Court injunction imposed on the 22nd of September, which prohibits causing the blocking, endangering, slowing down, preventing, or obstructing the free flow of traffic onto or along or off the M25 for the purposes of protesting. On the 30th of September, Insulate Britain posted that it had blocked the M25 for the third day this week and that it was now raising the tempo. It added that its actions were in breach of a High Court injunction. The protesters were moved by about 8:40 a.m. The allegations of contempt that are made in respect of this protest are that Biff Whipster, Ellie Litton, Gabriella Ditton, Stephen Gower and Stephen Pritchard willfully breached the M25 order in the morning of the 29th of October 2021 by endangering and slowing down the free flow of traffic onto or along or off the M25 for the purposes of protesting, in breach of Clause 2.1 of the M25 order, by entering onto the M25 westbound, anticlockwise, between junction 28 and 29 without a motor vehicle, in breach of Clause 2.6 of the M25 order, and refusing to leave the area of the M25 when asked to do so by a police constable, in breach of Clause 2.8 of the M25 order. Benjamin Bewes, Christian Rowe, Diana Warner, Ruth Jarman, and Sue Parfitt willfully breached the M25 order in the morning of the 29th of October 2021 by blocking, endangering, slowing down, preventing, or obstructing the free flow of traffic onto or along or off the M25 for the purposes of protesting, in breach of Clause 2.1 of the M25 order. By entering onto the M25 eastbound, clockwise, between junction 28 and 29 without a motor vehicle, in breach of Clause 2.6 of the M25 order, and refusing to leave the area of the M25 when asked to do so by a police constable, in breach of Clause 2.8 of the M25 order. The history of the protests involving obstruction of the highway is rehearsed in Hayatawin. It is unnecessary for us to repeat it. Where the body responsible for the strategic road network is aware of organized protests involving repeated obstruction of the highway, it is not a matter of criticism when that body seeks the assistance of the courts to prohibit such protests when they cause very significant inconvenience to members of the public. We do not consider that this demonstrates a political decision on the part of the highway authority, whether a decision of its own making or a decision at the behest of others. We recognize the genuine concerns of these defendants and others associated with Insulate Britain in relation to what is and is not being done to meet the challenges of climate change. Equally, they must recognize that a High Court judge acting wholly independently made the M25 order after balancing the convention rights of those involved with the activity of Insulate Britain against those of the general public. We are concerned only to enforce that order by such sanctions as we consider appropriate and proportionate. In doing so, we maintain the rule of law. There is no material dispute about the principles that apply. They are set out in Hayatawin at 49, and Bewes at 27-31. In both those cases, the court found that custodial threshold was crossed in respect of each individual defendant. In respect of the question of whether committal to prison should be immediate, each defendant made a free and deliberate decision to breach the order, knowing that the consequence might be imprisonment. Each did so as part of a group activity. In each case, their conduct was designed to cause significant disruption and inconvenience, targeting important national infrastructure during rush hour on a weekday. Each defendant knew that their actions would require police attendance, diverting officers from other policing functions and potentially putting them at risk. 29 October Junction 28-29. The westbound carriageway of the M25 was blocked by the protesters during a weekday morning rush hour for a period of 40 minutes. There was no incursion into the eastbound carriageway, but the presence of the protesters on the verge meant that the police closed the carriageway as a precautionary measure. There was a significant impact on motorists. There was congestion for 3 to 4 miles in both directions. Average speeds were reduced to 3 miles per hour on the eastbound carriageway, and 27 miles per hour on the westbound carriageway. There was, we accept, the potential to cause a serious traffic incident. 29 October Junction 21A, the protesters remained on the hard shoulder, and there was no incursion into the live carriageway. The protest lasted for around 25 minutes. The impact on motorists was minimal, aside from the distracting effect of the protest on fast-moving traffic. General risk of harm, aside from the specific identified harm in each case, the potential risks are obvious. Antecedents and totality. Ben Taylor, Benjamin Bewes, Biff Whipster, Diana Warner, Paul Sheikey, Ruth Jarman, Stephen Gower, Stephen Pritchard and Sue Parfitt have each previously been committed for contempt of court for similar conduct, and have been subject to orders of imprisonment, immediate in the case of Ben Taylor, discharged in the case of Benjamin Bewes, and suspended in the remaining cases. Ben Taylor and Benjamin Bewes took part in the protest on the 8th of October, which was the subject of the first application for committal. That application was issued on the 22nd of October 2021. Taylor and Bewes were served personally with the application. Each was aware of the application when he took part in the protests on 29 October 2021. This is a significant aggravating feature. It also raises a question of totality, that is, the need to ensure that the overall penalty is proportionate to the seriousness of the contempt. There is no reason to take a different approach to totality from that which would be taken when sentencing for criminal offences. The Sentencing Council's overarching guidance on totality states: consider what the sentence length would have been if the court had dealt with the offences at the same time and ensure that the totality of the sentence is just and proportionate in all the circumstances. If it is not, an adjustment should be made to the sentence imposed for the latest offence. Acceptance of breach at first reasonable opportunity. Each defendant fully admitted in advance of the hearing that they had deliberately breached the order, although, as we have found in the cases of Liam Norton, Orne Springerham and Jessica Corsby, the admissions were wrongly made. None of the defendants who now fall to be considered have ever sought to resile from those admissions. Up until the start of the hearing, none of them sought to disrupt the process and each had been cooperative. All attended court at the start of the hearing, and all made it clear at the start of the hearing that they admitted deliberately breaching the order. Individual circumstances of the defendants. The defendants were, we accept, all motivated by a genuine and deep-seated concern about the lack of government action in response to the climate crisis. A number apologized for the disruption that their activities had caused, but they did not regret their actions and maintain what they consider is a highly principled stand, that although unlawful, their actions were justified by the emergency that faces the whole of humanity. They were proud of their actions, ashamed of the government, and they acted, they said, out of love. In the course of these proceedings, none of the defendants evinced an intention to commit further breaches of the order, although again, some were more equivocal about their intentions than others, and, leaving aside Dr. Warner, only in the case of Benjamin Bewes was there a clear undertaking not to commit any further breach. Mr. Greenhall, on behalf of Benjamin Bewes, told us that everything he had said when he successfully purged his previous contempts of court applied equally to the contempt on the 29th of October 2021. He maintained the sincere apology that he had previously proffered to the court. His mother is elderly and unwell, and he is remorseful as to the impact that his imprisonment has had on both of his parents. He has made a determined decision to find different and lawful ways to persuade others of the importance of addressing climate change. That commitment is supported by character evidence adduced on his behalf. On behalf of Dr. Diana Warner, Mr. Greenhall told us that she is a medical doctor by training and has spent many years working for the NHS as a general practitioner. He relied on the observations in Bewes as to a dialogue between the court and those who commit acts of protest in breach of a court order. He said that Dr. Warner had now served the term of imprisonment that was imposed following the decision in Bewes and that she now gave a sincere undertaking that she would not breach the order in the future. That, he said, was the start of the dialogue. He invited the court to respond by not imposing an immediate custodial order and instead suspending any order. Those submissions had force at the time they were made, on the first morning of the hearing. Dr. Warner did not attend the hearing in the afternoon of the first day. Instead, she glued herself to the steps outside the Royal Courts of Justice. She did so in the knowledge of what the consequence would be. In Bewes she had failed to attend the start of the hearing. A warrant was issued for her arrest and the resulting order for committal was not suspended, see at 8-9 and 54. When Dr. Warner was brought back before the court, Mr. Greenhall said that if an order for committal was suspended then she would comply with the terms. Ben Taylor is in custody as a result of the previous committal order. In mitigation he relied on the fact that before he became involved with the campaign to insulate homes he had not committed any offence. He explained that the conditions in custody are onerous as a result of the COVID pandemic. He has to spend 23 hours in his cell each day. His partner is pregnant and is due to give birth in approximately 6 months. Biff Whipster told us that, aside from his previous committal for contempt, he has never received so much as a speeding fine or a parking ticket. He was asked to stand as a local councillor. He focuses on living with a small carbon footprint. He lives a frugal life, undertakes volunteering activities, and is in receipt of universal credit. David Nixon has been a care worker for 10 years, working with young people. He regards that as part of his identity, and considers his acts of protest as an extension of his care work. He has left his job in order to pursue his commitment to campaigning in relation to the climate crisis. Gabriella Ditton told us that she did not regret her actions and could not express remorse, albeit she regretted the impact of her actions on others. She felt ashamed that she was not with the 4 defendants who had glued themselves to the steps outside the court building. Her mother is terminally ill and she was worried about not being able to spend time with her mother if she was sent to prison. She said that she had no plans to breach the order again, and that none of us are malicious people, we are genuinely trying to do the right thing. Indigo Rumbelow emphasized that her actions were peaceful, accountable and carefully planned. The police had been called in advance of the protest so that they could attend and ensure the safety of the public. She said that she would continue campaigning until there is a change in government policy. She was not sure what form that campaigning would take. Paul Sheikey considered that the Insulate Britain campaign was a proportionate protest to secure action on the climate emergency. The protest had originally been planned for 8 a.m. At that point it was dark and wet. They delayed the start of the protest until the road conditions were safer. He had not decided what he would do, in terms of protest activity, in the coming months. Ruth Jarman said that she answered to a higher authority, love and life. She did not wish to be a bystander in the face of the climate emergency. She was sorry for the effect of the protests, but she did not regret breaching the order and could not make a promise not to do it again. She had no contempt for the court, but she did have contempt for the system. Stephanie Ehlert described herself as a scientist, a mother and a sister. She had been brought up not to consume unnecessarily. She delivers food parcels to the homeless, is on universal credit, and sometimes relies on food donations herself. She explained that the police were called 10 minutes before starting the protest so that they could ensure safety. Stephen Gower is a volunteer advocate for the homeless. He has received a community award. He gave examples of cases where he had sought to procure help for others but public bodies had failed to act and nothing was done. He felt that there was nowhere else to turn other than civil non-violent direct action. Sue Parfitt is an Anglican priest. She said that everything she had done was motivated by her Christian faith. She wished to bear witness to the truth of the science regarding the climate catastrophe and to respond to God's command to stand up for the poor. She, and her fellow defendants, were people of high principle willing to sacrifice liberty, if need be, for the sake of waking up the government to the insanity of the failure to address the climate emergency. Christian Rowe believed his actions were necessary and proportionate. He stressed that he acted peacefully at all times and that he was cooperative with the police. He said he was only trying to shine a light on the truth about climate change. Ellie Litton described herself as a programmer and quite an ordinary sort of person. She lives quietly in a flat. She said she was sorry for the stress she had caused, but was not able to apologize because she purposefully broke the injunction and decided not to attend the afternoon of the first day of the hearing. She said that insulating homes would significantly reduce the number of deaths each year that occur through fuel poverty. She said that she would keep protesting until things change. Stephen Pritchard said he was motivated by the selfless example of his parents who modeled compassion, and his grandfather. He had spent his adult life trying to make the world a better place. He had planted tens of thousands of trees and dug hundreds of wildlife ponds. He had tried writing to his MP to effect change, but without a positive response. He considered that the use of civil law was a politically motivated attempt to bypass the decision in Ziegler and to avoid a jury trial. He had breached the injunction 5 times in the past, more if one included occasions on which he had encouraged others to do so. Teresa Norton is an active member of the Labour Party and is an elected local councillor. She volunteers to help at the local food bank. She apologised to the people who were inconvenienced and disrupted by her actions, but she would do it again. She would continue to fight for climate and social justice. She was willing to serve a prison sentence in solidarity with those sentenced before me. In mitigation, she told us that she is the primary carer for her 92-year-old mother, although she had put contingency arrangements in place, and she has counsel and volunteering commitments. We consider that the custody threshold is passed in relation to each individual defendant. In other words, having considered the possibility of imposing a fine, we have concluded that each contempt is so serious that only a custodial penalty will suffice. In each case we make a reduction to reflect the restrictive custodial regime that is continuing to operate in the light of the COVID-19 pandemic. In respect of those who entered the live carriageway on the 29th of October 2021, Benjamin Bewes, Christian Rowe, Diana Warner, Ruth Jarman and Sue Parfitt, we consider that the 2-month term that was imposed in Bewes is, in principle, the shortest period of imprisonment which properly reflects the seriousness of the contempt and is proportionate, taking account of prison conditions and the admissions. 3 months before allowing for the admissions. In the case of Benjamin Bewes, the term falls to be adjusted to reflect the aggravating feature that the contempt was committed after service of earlier applications to commit for contempt of court. In the case of Benjamin Bewes, Diana Warner, Ruth Jarman and Sue Parfitt a further adjustment falls to be made for totality. Taking these factors into account we consider that the appropriate term following a contested application would be 60 days in the cases of Benjamin Bewes, so 40 days after reducing for the early admission, and 45 days in the cases of Diana Warner, Ruth Jarman and Sue Parfitt, so 30 days after reducing for the early admissions. In the remaining cases there was no incursion into the live carriageway of the motorway. Although the level of harm caused was slightly different between the two protests, see paragraphs 31 and 32 above, is not possible to distinguish between the level of harm that was intended, and we do not consider it appropriate to draw a distinction in the sanctions to be imposed. We consider that the appropriate term in those cases is, in principle, 9 weeks, reduced to 6 weeks for the admissions. In Teresa Norton's case, in the light of her caring responsibilities, we consider that the appropriate term is 4 weeks. In the case of Ben Taylor there is the aggravating factor that the contempt was committed after service of the application to commit for the earlier contempt. In the cases of Ben Taylor, Biff Whipster, Paul Sheekey, Stephen Gower and Stephen Pritchard the terms fall to be adjusted to reflect totality. Taking those factors into account we consider that the appropriate term is 48 days in the case of Ben Taylor, reduced to 32 days for the admission, and 36 days in the cases of Biff Whipster, Paul Sheekey, Stephen Gower and Stephen Pritchard, reduced to 24 days for the admissions. This results in the following terms: 2. Ben Taylor, 32 days, 3. Benjamin Bewes, 40 days. 4. Biff Whipster, 24 days. 5. Christian Rowe, 60 days. 6. David Nixon, 42 days. 7. Diana Warner, 30 days. 8. Ellie Litton, 42 days. 9. Gabriella Ditton, 42 days. 10. Indigo Rumbelow, 42 days. 13. Paul Sheekey, 24 days. 14. Ruth Jarman, 30 days. 15. Stephanie Aylett, 42 days. 16. Stephen Gower, 24 days. 17. Stephen Pritchard, 24 days. 18. Sue Parfitt, 30 days. 19. Teresa Norton, 28 days. Ben Taylor is currently in custody. It does not seem to us to be right to impose a suspended order which in practice will only be effective after his release. He will therefore be subject to an order for committal to custody for a term of 32 days, to run consecutively to the existing 6-month term. In the cases of Teresa Norton, Diana Warner, Ellie Litton, and Stephen Pritchard their actions in gluing themselves to the pavement in front of the court building, rather than attending the hearing, shows that they are not prepared to engage in the dialogue referred to in the cases. The orders for committal to custody in their cases will therefore take immediate effect. In the remaining cases, we consider that the reasons given in Bewes for suspending the orders for committal apply. In particular, it remains the case that no further protests organised by Insulate Britain have taken place over the road network in breach of injunctions granted by the court. There is no evidence that further protests are imminent. None of the defendants have said that they have any intention to commit further breaches of the court's order. Mr. Bewes has gone further, and has apologised for the contempt of court, undertaken not to breach further court orders, and committed to finding other ways to demonstrate his sincere commitment to communicate to others the urgency of the climate crisis. Accordingly, we will suspend the orders we have made in each case, save that of Ben Taylor, Teresa Norton, Diana Warner, Ellie Litton, and Stephen Pritchard, on terms. In each case we direct that the order for committal shall be suspended for 2 years so that the committal to prison shall not take effect so long as, during the next 2 years, the defendant does not take any of the steps that are forbidden by paragraphs 2.1 to 2.10 of the Order of Lavender J dated the 21st of September 2021, the M25 for the purposes of those paragraphs being defined in the same way as paragraph 1 of that order. This condition will apply whether or not the Order of Lavender J remains in force.